Christie is a Canadian lawyer with 20 years' experience. He recently defended Imre Finta, a Hungarian-Canadian accused of war crimes, under new laws similar to those passed by the House of Commons to bring alleged Nazi war criminals to trial. This was overturned by the House of Lords, who threw out the proposed legislation last month. Mrs. Thatcher now intends to reintroduce the bill. Imre Finta's was the first case ever brought under such laws. In May, he was found not guilty on all counts. Douglas Christie believes that such laws are fundamentally unjust, that the passage of time inevitably clouds the memories of those involved, and with the vast amount of published material, both fact and fiction, about the war, it is impossible to find an unprejudiced jury to hold a fair trial.
I was the defense lawyer in Canada's first war crimes trial. On May 25th this year, after 8 months of court proceedings, a jury of 8 women and 4 men found Imre Finta not guilty of 4 counts of war crimes and 4 counts of crimes against humanity. My experience as defense counsel in the first war crimes trial under these laws, similar to those proposed by your government here, gives me unique information to share with you. They are absurd, in my opinion. Mr. Finta has lived in Toronto for over 30 years. The Hungarian restaurant he ran was a famous meeting place for celebrities. Before the war in Hungary, he was a dancer, ventriloquist, and theater performer. During the war, he became a captain in the Hungarian gendarmerie, responsible for confiscating property from Jews who were being deported. In 1987, he was charged with robbery, kidnapping, forcible confinement, and manslaughter involving 8,617 Jews from Szeged in southeastern Hungary. The trial became a battleground for pressure groups who wanted to refight the Second World War. 22 Jewish witnesses from around the world recounted their personal suffering with often conflicting stories. A number of things happened which points to the futility and the injustice of the way these laws work. The war was over 45 years ago, and now we must reopen old wounds and try to reconstruct events. It simply doesn't work. Before this trial, Finta had faced 10 years of accusations and even a firebomb attack at his house. His wife died as a result. He lost his house and all his assets in costs over a defamation case he was forced to discontinue through lack of funds. The resources for the prosecution in the Finta case were enormous. The Crown had 2 years' preparation ahead of us. They had a large staff and seemingly unlimited budget for this, their first case. The defense consisted of myself, my junior, and my clerk. We could never match the other side. The government negotiated access to foreign archives in Hungary by a diplomatic agreement not extended to us. They got access to the International Tracing Service of the Red Cross at Arelsen, West Germany, which holds all the concentration camp records. Access is normally restricted to the 4 major powers plus Israel. This too was denied to the defense. This was important because archival documents were for the first time admitted into evidence without a live witness being called. Many of the writers were dead and so could not be cross-examined. The Crown got them in as business records. This, in my view, was unjust. The Crown had the assistance of governments in Israel, Australia, Hungary, and Germany. The defense did not. What about the presumption of innocence? Can it result in a fair trial when such power to get evidence is on one side? The memory of witnesses was naturally a problem for both sides. After cross-examining the Crown witnesses, I saw they relied more on media coverage about the accused than real memory of anyone at the time. People don't remember accurately 45 years later. They just repeat the story. If we are to have fair trials, accurate, detailed recollection is vital. This was not available from the witnesses. At one stage, we went to Hungary. Judge, prosecutor, and defense were subjected to Hungarian judicial practice. Conflicts resulted because cross-examination was severely limited by the Hungarian judge. Cross-examination is the major defense instrument, and it was frustrated. The media plays an enormous role in stimulating public interest in these trials. Everybody is interested in the war. But since 1945, for 45 years, we've watched movies, read books, seen television about the Holocaust. One side is always good, the other side is always bad. In real life, things are not so simple, but the media likes simplification. For these reasons, no jury can approach the subject without bias and look at the facts objectively. During the Finta trial, the movie music box was released.
Mr. Ramos, do you remember meeting a man there in the special section known as Mishka?
Yo, Ishtanim, everybody know Mishka. Everybody afraid. Mishka, worst.
Why was that, Mr. Ramos? Why was he the worst?
Mishka and his group enjoy.
Mr. Ramos, what was it that Mishka did at the interrogation center that you saw him enjoying?
Mishka liked to kill Jew. Mishka liked to kill Gypsy more than Jew.
A Toronto newspaper drew such a close parallel with the Finta case, they put a frame from the movie alongside a picture of the accused. The same hat, the same coat, the same camera angle were used. Naturally, the movie painted a lurid picture, much more interesting than real life. A juror was seen going to the movie. The public saw it and assumed it was about the accused. It could be said the media presented the prosecution's case better than the prosecutors. The role of the historian has taken on a new meaning in these trials. Historians are now being allowed to testify to events in history as if they were there. Historians' opinions were admissible as evidence under new rules for these trials. Consider the effect of old age and ill health on the accused. My client was 78 years old and in poor health. If he were guilty, I suppose that wouldn't matter. But to have a fair trial, let's presume he is innocent. Not exactly a novel proposition. How can he travel to Israel and Hungary and endure long months of preparation? A younger, fitter man would be hard-pressed to do so. For an old man, it is impossible. It's like shooting fish in a barrel for a prosecutor. His memory for detail after 45 years is poor. He is too frail to withstand cross-examination. If he doesn't testify, as he has a right not to do, will the jury see the injustice in all the lurid pictures painted about him? How can his defense counsel be properly instructed when he is old and weak and can't remember? The scope of these cases is enormous. Evidence far beyond the immediate case is admissible as so-called background. The accused becomes a scapegoat for everything that went wrong in wartime. The whole Holocaust story is placed in evidence. The House of Lords here recently defeated these laws. I commend Lord Shawcross, a former prosecutor at Nuremberg, and other learned law lords for the courage to stand for principle and stop such unjust trials. The Finta case taught me to fear the power of the state more than ever. Once the state machinery gets rolling, it's hard to stop it with moral and legal arguments. We estimate the trial cost $5 million. There appeared to be no limits. Experts and witnesses were brought from all over the world. I was made to realize that justice in wartime is not so simple as the movies would have us believe. I feel moved to say, as the first person to defend someone under these laws, for the sake of justice, don't let them pass in Britain. The worst results would be a serious miscarriage of justice. At best, and after a long, painful trial, the jury would do as they did in the Finta case, throw it out. The Crown, with its infinite resources, has chosen to appeal the acquittal of Imre Finta. He is a tired old man, having lost everything, and will likely not live to see the result. Is this justice, Mrs. Thatcher? Are these trials just propaganda pieces, or are they really seeking justice? My experience makes me doubt the latter. Potential defense witnesses fear for their safety in this atmosphere of guilt by association, and they stay silent even if they could exonerate the accused. Often they are old and frail. This means the defense cannot show the innocence of the accused because of the fear of these old men. And of course, many more potential witnesses are dead already. For 6 months, I watched an old man sleeping through a trial with his feet up on a chair. This man lived a full, constructive life for decades in Canada, well known and honored by all kinds of leading citizens. He never hid his wartime role as a gendarme. This trial did nothing to improve the country, ethnic relations, or justice and law. Why make the same mistake here? Have the persecuted become the persecutors?